Welcome, everybody, to the new California Labor Law Odyssey, a show that brings attention to the ever-growing and overbloated 1,050-page labor law digest. We're here to help educate you on what's happening out there right now with businesses like yours, and to help you find ways to avoid costly lawsuits that are on their way to an all-time high here in California. From the man who's been there and done that and is battling back, our host, Tom Manzo. Hey, Tom.
Paul, good morning. How are you?
I am so excited to hear this show and to participate in it. I'm a small business owner. I have no idea about all this labor law stuff. I don't want to hear about it. I don't want to know. I'm going to be deaf, dumb, and blind and just hope I fly under the radar here. But you're telling me that there's a whole world of hurt waiting for those of us that don't pay attention to this thing.
Yeah, that's a big issue. That's why I'm trying to advocate, is most people really don't understand the laws that are out there and the consequences.
Yeah, for businesses like ours, small to big. Okay, so give us a background. Who are you?
Well, I'm the founder of the California Business and Industrial Alliance. It's a nonprofit organization, and we're committed to reforming labor laws, especially with the Private Attorney General Act, known as PAGA. They refer to that as the Sue Your Boss law.
And that's what we're going to talk about today, I know, right?
Yeah. Late lunches, misclassified bonuses can cost you millions. I know this because the company that I work for was a victim, along with more than 8,000 businesses last year.
Wow. Well, I look forward to starting the conversation in this inaugural episode to learning more about this crazy thing called PAGA. Who'd you bring along to help explain this?
Well, we brought Robert Pepple, and he's our first guest.
And he's ready. Boy, he was quickly taking notes and writing stuff down here, and he's going to give us a PAGA 101.
Well, if I may interject, I'm a guest. I didn't realize this was optional, Tom.
Someone
should have told me.
Well, he was slightly forced.
I'm definitely here, that's for sure. I'm not going anywhere.
He thought he was going somewhere else.
Well, tell us who you are and why you are here. What do you bring to this discussion today?
Yeah, we got the first part right. My name is Rob Pepple. So I am a labor and employment attorney. I'm also corporate counsel for PAGA, the organization that Tom has championed like a destroyer.
So he did kind of urge, there was a little strong-arming to get you to come down here, maybe.
I've been so fortunate to kind of watch Tom as he's basically crusaded along the way. What he's done in the year has been truly heroic. Right. They sued the wrong person, I'll tell you that. So I am corporate counsel for PAGA. I also am an employment litigator at the law firm Epstein, Becker & Green, along with my boss and good friend, Rich Fry, who you all have the opportunity to listen to. He's hilarious and very knowledgeable.
Okay. I'm going to get you to lean in just a little bit so we get you in the camera there, too. Great.
So I'm just not real handsome, so I'm not sure how
I know you keep trying to drop out.
But, well, I'm happy to oblige. Again, I realized I was a guest.
This is real people on a real show.
That's not what his girlfriends
say. I see. Well, let's not go there. Let's not open up another whole mess here with girls and girlfriends here. All right, so tell us, what the hell is PAGA? And where the heck did this beast come from?
So, yeah, let's start with the framework of PAGA. And for those of you listening, this is going to sound boring to begin with, but give me some time, give me some steam. I promise it'll make sense. So, the Private Attorney General Act is California's response to being lazy on its own accord. As we mentioned in the opening of this podcast, the California labor laws are over 1,500 pages long. The type is about 8 font. It's very, very difficult to even know what's in the law, much less comply with anything else.
And are we one of the bigger labor law digests in the country? My perception always is that California has more labor laws than most.
The largest, but in this case, bigger is not better.
Okay, all right.
That's correct. California is the most vicious and difficult climate for employers in the United States. So what PAGA did is essentially said for any violation of the labor code, it's going to deputize or basically put a star on your chest like a private sheriff to go out and essentially sue your employer for any violation of the labor code.
Because they feel what? That they don't have enough people to enforce or to go out and find these violations, and therefore we're going to deputize everybody and turn you into vigilantes?
Exactly. And although that is kind of a farce, I mean, the size of the California government, I think it's 2.3 million employees. If they can't find someone to enforce these laws, maybe they shouldn't pass them. So Essentially,
Don't
yes.
get nasty now on us here. Okay,
It's okay.
all
Well,
right.
so I do fight these every single day, and my heart goes out to my clients for truly trivial violations and basically technical issues. So to move on to the penalty structure, PAGA essentially.
And when was this passed? I'm sorry.
2004. Would you like me to go through the history first or the
Yeah,
structure?
why did they? Let's just talk about the history. But why the heck did they feel the need to put across this private attorney general act that privatizes people to act like the attorney general and sue you?
Yeah, well, all the legislative findings are what you would expect from a legislature like California, saying that we need more vigorous enforcement of the employment laws, we are underfunded and understaffed. But classifying it as a need to pass it is probably an overstatement. Indeed, the original PAGA statute was passed by only one more vote than the bare minimum in the state assembly and by the bare minimum in the state senate. It
wasn't overwhelmingly popular here.
No, it was not. And the reform efforts began almost immediately. Indeed, in the following year, there was aggressive reform efforts put into place, and there was actually some amendments made to it to qualify and to basically restrict some of the problems with law, which give us some of what we have today. Well, yeah, so essentially that's the origin of the statute, is essentially wanted to deputize California employees to do the job of California, the LDWA, which would be the Labor and Workforce Development Agency for it.
And I'm assuming since it passed that lawsuits have ballooned.
They are completely out of control. I'm trying to remember what the most recent stats were. Tom, you seem to recall. What were the number of lawsuits that have been filed under PAGA versus...
It was about 8,000. We're trying to get new stats. They didn't really start keeping track of this until September of 2016. So
From 2004 to 2016, they didn't really
no
measure?
Records. No records available in 12 years. So
wow.
And I believe in 2003, 2004, when the law was passed and then actually put into place, the budget, they didn't have enough dollars in the budget, and that was one of the reasons they decided to deputize the attorneys, if I'm not mistaken. So we can thank Gray Davis and the other main supporter of the bill. I think he's in jail now, isn't he, Rob?
That might be accurate, but I won't want to defame anyone, not in our first inaugural podcast.
Yeah, exactly. So I'm just I'm trying to wrap my head around this. So who do they deputize? They deputize ordinary people? No, they deputize ordinary people to go find a private attorney, and that attorney can then sue on behalf of what? The state?
That's exactly right. And so the people who are deputized are technically the aggrieved employees. And under the law, the aggrieved employee is defined as any person who was employed by the alleged violator against whom one or more of the alleged violation was committed.
Okay, and give us some place to go find this. There must be a statute or something. If anybody really wants to go look at this law, is it short? Is it long?
It's long, convoluted, but you could start at California Labor Code 2699.
2699. All right, if anybody really wants to get technical here and dive into it here. All right, so now if I feel that something's happened to me that isn't right, and I have some grounds to sue, I go get an attorney, and they then file a lawsuit on behalf of the state, and the state is basically allows them to sue me? It's not a private suit. It's a what? It's a suit that they bring on behalf of the state?
That's right, and that's how it's been qualified by the courts, and we'll get into some of the reasons why that's important and problematic a little later. The official term is called a key tam action. It's supposed to be brought on behalf of the state of California, but there are some procedural hurdles that an employee must go through first. And although it's been changed, indeed there are some legislative changes in 2016 that extend some of these timetables. It's too much of the weeds for where we're at this point in time, but essentially an employee sends a letter to the LDWA, the Labor and Workforce Development Agency, and by certified mail, and provides notice to the employer of the violations. And again, I think that's an overstatement. Indeed, dealing with these letters on a daily basis, these letters are boilerplate. They're very nondescript. The facts are almost non-existent. They must send out figures.
They just meet the criteria to start. And what does that provoke? A hearing in front of the labor people, or does that automatically go to some judge somewhere?
You would think so. You would think that would be the way it should go, but no, that is not how it works. Indeed, there are some timelines for the LDWA to investigate, but essentially what happens is the LDWA investigates less than 0.75% of these cases.
What?
Yeah, they don't look at them. I mean, we think they get lost, and indeed, as Tom mentioned earlier, we think some of these things get lost. There's no records of them, and essentially, if nothing happens after 65 days, the employee gets to sue and wield the power power of the California state against private employers.
So they've notified the state body that oversees this. We think there's a violation, and we've notified the employer. And they're supposed to go investigate this and see if this is credible enough. Can they decline it? Can they say, no, this isn't credible? We've investigated it and we think this is bogus or not actionable?
Right. So the LDWA does have the option to investigate. I think originally it was 33 days. I think it's been extended to 65. The timelines aren't important here. But essentially what happens is that the LDWA will issue a notice of intent to investigate, or they don't. If they do nothing, literally if there's no response that's forthcoming from the LDWA, which is the case in the vast majority of circumstances, after the expiration of the 65-day time limit, people can just bring suit.
And when they sue, I'm still trying to wrap my head around this. So does it say Paul Roberts, employee of this company, on behalf of the state of California? Or
no, it's got its own individual cause of action. A lot of times people will file what's called your classic wage and hour lawsuit alleging meal breaks, rest breaks, all of that, and then they will amend to add a PAGA claim, but the name of the plaintiff doesn't change because they're still the aggrieved employee for the purposes of the suit.
And does it ever turn into a class action suit where it becomes hundreds of employees and this type of thing, or are there hundreds of actions that are taken?
Indeed, that is what they are doing. So the PAGA action is a representative action as distinguished from a class action, and there's an important distinction there which we might also have time to get to later. But essentially the individual aggrieved employee is acting as the representative on behalf of all other aggrieved employees.
Right. They're representing this group of people that might or might not be affected like they are. They think they are.
Correct. And actually what's interesting is a pretty recent case. The name escapes me at the moment. One would think that an aggrieved employee would say, well, I suffered late or short or missed meal breaks, and therefore I'm bringing a representative action on behalf of other employees who were similarly situated, a term of art that you use in class action procedure. Right. PAGA does not work that way. Indeed, because PAGA is an action on behalf of the government, the individual plaintiff or representative is indeed allowed to go over and say, you know what, even though I don't allege that I personally suffered pay stub violations or any other type of violation, they're allowed to represent people that are not like themselves.
The other employees end up in the class whether they like it or not.
Correct.
They're all part of the group. Okay, and then does the state, when this lawsuit comes to trial, do they show up? Do they send attorneys? Do they participate in anything else?
The majority of them never end up in trial, Paul. They normally are settled in mediation due to the expense.
So it's cheaper to just pay them. So I don't want to over-characterize this, but it almost seems like it could be a holdup. Where I'm going to sue you unless you pay me a bunch of money, and it's cheaper just to pay you to make it go away.
That's exactly what it is.
Indeed. And to answer your pointed question, because I think it was a good one, is that no, the state is essentially abdicated all responsibility, oversight, or participation in this, which is very different from your typical qui tam action. Indeed, the state in those qui tam actions often has direct oversight, or actually will interject or intercede or take over the litigation if it's a matter of import.
Right. If you're suing on behalf of the state, then you think the state would at some point step back in and say, okay, is our interest being served? Are you litigating this properly? Is it a good case? All those kinds of things. That do you think that? But you're saying they don't have the time, talent, or interest, whatever it is, money, something, and they just, if you notify them I'm going to do it, if they don't take any action to stop it, it goes forward on its own, and they just wait to see what the result is.
That's correct. I mean, indeed, the LDWA must receive a notice of nowadays. It didn't used to be this way, but the recent reforms in 2016 required the employees to furnish a notice of any settlement to the LDWA, and courts must approve the settlement as reasonable as to PAGA plaintiffs' representative actions.
And part of that was the state realized they weren't getting their cut that they should have been getting.
Oh, they get a cut because they're a participant?
That's right, because they're all negotiated deals. So the only thing that isn't negotiated is the attorney's fees, right? So the penalties...
Those dirty attorneys. We just got to get rid of all those.
We're the worst.
Not guys like Rob. It's the other guys.
Those other guys. Not my attorney.
I've got other problems. I've got other issues.
It's not my attorney. It's the other attorneys. All right. So let's say I'm going to just pick a figure. It settles for $500,000. The government, state of California, gets some of that money.
Oh yeah.
Well, let's go back and let's unpack it. Now, if there's a judgment for which, again, as Tom said, almost none of these things go to trial. Indeed, no one knows how to try these cases because they don't have to meet classical class action requirements, which have procedural safeguards and things that help the case move through trial and be. Well, let's back up. A class action is essentially the constitutional procedure saying, look, apples are like apples, oranges are like oranges. So instead of bringing 100 individual trials, let's just treat everyone as the same.
Right.
And you guys have all the same issues, you guys have the same problem. It would be efficient for us to adjudicate this as one foul swoop. Because PAGA does not have to meet those requirements, there's a case on this. Once it gets to trial, all those reasonable procedural and constitutional protection and safeguards, it's a mess because there's manageability problems. It's a bunch of mini trials, and so that's why none of these things are ever really litigated.
And I've had things in the mail. I've never really participated in class action suits, but by God, I get notices all the time. Gee, you bought something at some store, and we're suing them, or you were part of some credit card company, and we're suing them. And whether you know it or not, you may be eligible to receive something. Do you want to opt out? You're in unless you want to opt out and pursue your own action. And of course, I never do. Most of us never do. And then maybe someday I get $20 or $100 or a gift certificate or something in the mail because I'm part of this class action suit from these people I know nothing about. You're saying that, so does this preclude all these other individuals who may be affected from filing their own PAGA suits? Or, I mean, once somebody comes forward, does that settle it for all the other employees, or can they say, no, I want to do my own PAGA suit. I'm going to fight it all over again?
Yeah, so under PAGA, there's not your typical opt-in, opt-out procedures. Again, that's a class action procedure and issue. Because it's brought on behalf of the state, indeed, the individuals are kind of a fiction, right? The state's the one bringing the penalties, and now might be a good time to go into the penalty structure. The classic penalty structure, originally, PAGA plaintiffs were entitled to recover all of the civil penalties. The later reform that came a year later restructured the penalties such that the state is supposed to get 75% and 25% is going to go to the aggrieved employees as a group.
What? Well, I got to hear that one again here. Yeah. So $500,000 gets some employee said, and we'll talk in a moment about all the kinds of things they can sue for. I think that's an important thing to discuss. Maybe we'll do that after the break. But right now we're trying to just get this structure and history of this thing in place. So somebody feels they didn't get their lunches or something, some labor violation. They notify they hire an attorney and notify the state organization, we're going to sue. If they don't stop it or investigate it or say, no, this is not a legitimate case, it moves forward, and the state then waits to hear back how it's settled, and the employer, in most cases, just says, okay, I'll pay up, we'll negotiate a settlement. The employer then pays this money to who? They pay it to the individual, and the individual gives the state their cut, or they pay it to the state, and the state gives the individual a cut?
The second way is how it should work. Indeed, in most key TAM actions, that's how it's supposed to go. But if there was a judgment, and the reason I'm making a distinction here is, as Tom alluded to, most of these cases are settled in what's called private mediation, which is a non-binding forum where people can basically make backdoor deals, and it's all shielded under privilege.
Right.
And so with a typical judgment,
arbitration, so it's done quicker, cheaper, but it's all sealed.
Correct. Well, arbitration is a binding procedure. If an arbitrator says do X, you must do X. Mediation, we can all just walk away in the middle of the day.
Well, I didn't know that. Okay.
Yeah, exactly. So arbitration is binding, and mediation is all voluntary. And there have been mediations where someone's come out with an opening demand of $300 million, and my client got up and walked out the door. We were there for 5 minutes. So arbitration doesn't work that way. But yeah, so that's how it's supposed to work, is that 75% is supposed to go to the state, 25% to the aggrieved employees. But here's the dirty little secret. And
you got lots of dirty little secrets.
It's a terrible,
dirty little law.
It's a dirty little exactly,
and not in a good way.
Yeah. So the problem is that plaintiffs' attorneys have been wielding PAGA because of the key TAM nature of it and the unique aspects.
Spell that again, just so anybody wants to go look that up. What is
QUITAM? I believe it's right. It's Latin, so I think that's right. I mean, I'll look it up at the break.
And what does that mean, the QTAM?
Oh gosh, the actual Latin translation, I wouldn't be sure.
We'll look it up.
Yeah, I know it means on behalf of the state. The state owns the lawsuit.
I see. So you bring it. an attorney goes, you go hire the attorney, and the attorney does this, what, on spec or on a fee or something here?
Well, essentially, it becomes part of any other type of lawsuit. So it's as if they're bringing a regular wage and hour lawsuit for meal breaks and rest breaks,
Right.
only now it's like they've been supercharged like Captain Planet with the power of the state. And not saying all the vehicles and weapons that we use to basically make the litigation fair and, the procedural safeguards don't
Right.
apply.
But what's important to really understand is that attorney that is suing on behalf of the employee, they get 100% of their fees. They get paid 100%. So the 75 that goes to the state and the 25 to the employee on the penalty and what's owed to the employees, all of that is negotiated in mediation.
So give me just a typical scenario of money. I know this is a lot about money here. So again, I'm just going to pick $500,000 or let's make it simple. $100,000 is a settlement. Well, first of all, what is a typical? What is there an average?
$1 million.
$1 million.
That's low. That's a low amount for a company of 100 employees.
Higher than that.
Yeah, indeed. There is some new case law out there that really brings down the hammer. I would say the pure exposure on a typical wage and hour case plus a PAGA action, you'll see an opening demand at mediation of $25 or $26 million.
What?
Yeah.
For how big a company?
100 employees.
Okay, so that's not a very big company.
They use the penalties as a negotiating tool. That's the weapon. That's the weapon.
All right, so I'm going to just go smaller just so I can make the numbers work in my head here. So let's say there is a settlement for $1 million. Okay, is that a typical settlement?
Let's use it. It's a good round number.
All right, $1 million. The employer has to fork out $1 million. I'll do this through mediation. Please don't take this to law. To a lawsuit, to a court, because that'll cost me even more money and I might get a bigger, fatter judgment and whatnot. You got me. I hate it. Whether I agree or not, here's $1 million. Go away. Now, does that shut off all the other employees from suing me, or do I have to go through this 100 times with all 99 other times there?
Well, let's take two approaches here. Let's say it's a pure PAGA mediation.
Right.
Pure PAGA first and foremost, the attorneys get their cut. That's the first thing that comes out.
And out of the $1 million, I guess that's what started this. $1 million, employer hands over $1 million to somebody. The first person to take their cut are what? The attorneys?
Yeah.
The attorneys.
And let's compare the Google. We have stats on a Google lawsuit. Google's been hit several times, several different other classes.
All right,
and there was one that settled for $1 million recently, and they got the attorneys on that case got about $340,000.
Wow.
Yeah, 33% is not. It's very normal, very.
So
typical.
a third of it goes to the attorneys right off the bat. It's a very lucrative thing for them to chase then and pursue. Third of it goes to them. And then there's 2/3 left, and of this 2/3, you're saying roughly 75% of that gets swiped by the state next?
That's yes. In a pure
It wasn't
PAGA,
that much, but
in a pure PAGA mediation, theoretically, that's how it works. That should work, but that's not how it typically goes. Remember that these PAGA actions are typically paired with your classic wage and hour class actions.
Okay.
So typical meal breaks, typical rest breaks. And what typically happens is that plaintiff attorneys use PAGA to get around some important decisions. One thing that came out from the United States Supreme Court, which just has some logical basis for what they do, is that arbitration agreements.
You only qualified it.
Compared to California Supreme Court, yeah, the U.S. Supreme Court is much better.
Okay.
So, but what happens is Epic Systems essentially said, you know what, guess what? If you have an arbitration agreement that says, I will arbitrate, guess what? You must arbitrate. And in a lot of these arbitration agreements, we have what are called class action waivers, which means that individual can't bring up an action on behalf of everyone else, only themselves. PAGA, because it's as a key time action brought on behalf of the state, there's a case called Iskanian out there that says, look, the government didn't agree to arbitrate with you, therefore this doesn't apply.
So maybe in your labor agreement, either your union agreement or your individual employment agreement, it might say what you said. We got to arbitrate this.
Right. Ineffective as to PAGA.
But a PAGA thing can invalidate that because the state didn't sign this.
Correct. And so what you have at these mediations is that, well, yeah, we'd have to individually arbitrate our individual statutory labor code claims, but we've got you as a representative on PAGA. So just pay me, Mr. Plaintiff's attorney, all the damages that we might be owed as a class for the wage and hour violations at the very end of the mediation, and we'll throw $10,000 at the PAGA action. So the actual claim that got you to mediation on a class-wide basis, PAGA, at the end, because the plaintiff's attorney doesn't want 75% to go to the state. They want as much money as they have. So it's $1 million.
Don't settle it as a PAGA then. Just give me, we got two separate actions here. A little bit of money goes to PAGA and the state can get some, but the majority of it goes to my client's claim here.
Exactly. So in your hypothetical, the $1 million, you get to mediation. Okay, $10,000 goes to PAGA, so $7,500 goes to the state, $2,500 to his aggrieved employees. Now the attorney's pot of money is closer to $333,000. And then the rest of it goes.
And then don't forget, you have people that write the checks. They write the checks to all the employees, so they get paid a nice, handsome fee as far as that's concerned.
Say that again. You lost me on that one.
What Tom's talking about, there are these things that when you have these
claims
large
administrators.
That's right. Yeah, you need someone to kind of organize
have one
the
of
checks.
those.
Yeah,
I see. So there's another person you got to pay. If people start lining up and say, you need one of these, and you need one of these, and you need one of these, and everybody's got their hand out.
You know, the one case I wrote a few op-eds about, and this is one of my favorites, is Uber Technologies.
Okay.
So they're fighting, with a lot of these labor laws. So they recently had a settlement, and that was $7.5 million.
Wow.
Okay, $7.5 million.
Here in California?
Here in California.
All right.
The lawyers got $2.3 million.
Wow.
The state did the best they've ever done on one of these PAGA lawsuits. They cleaned out with about $3.6 million.
I don't hear a lot of money left for the poor employees.
Hold on now. You got that claims administrator I was telling you. And I think that's why Rob said, you know what, you got to bring this up.
Yeah.
So $775,000 for the claims administrator. What I want to do is I want to be a claims administrator.
Yeah, that's a
good
I
gig.
can write checks.
And get $700,000 for doing it. All right, so he got $700,000.
How much do you think the Uber driver got? Give me a guess, please, Paul.
I'm trying to do the math in my head. It doesn't sound like much.
What do you think? Just guess.
Keep in mind, California enacted this law to protect employees.
Yeah.
$7 million was the original judgment.
7.5.
7.5.
Right.
And the individual driver who brought this case must have gotten $1 million.
No.
$100,000.
No, oh no! The people that bring the case get way less than people think. I think the actual guy that brought the case only got about $2,500.
$2,500 out of $7.5 million.
Well, hold on now. How much did all the drivers get?
Each individual driver.
Well, they must have each got $2,500 then.
$1.08. 1.08.
So this one guy who stood up and fought the fight and brought it forward, hired the attorneys, went forward and went through all the thing. He got $2,500, and all his other drivers that got pulled into the suit each got $1.
Correct. Well, $1.08.
Oh, $1.08. I'm sorry. Let's be fair.
You got to cover the California tax.
And so everybody got $1. And then the state got how much? $1 million or something?
$3.6 million.
3.6.
And they are protecting these employees, though. It's a great thing.
Super effective.
Yeah, I can see. Wow. Why isn't this front page news? Why isn't this an op-ed in every editorial section? Why aren't people marching through the streets and
I tell
holding
people
rallies?
It's a silent killer, because a lot of people are afraid to speak out. They're afraid to talk about it. They're afraid of retaliation. They don't want to look like they're anti-labor, anti-Me Too movement. With everything that's going on in today's society, they're afraid to raise their hand and say, wait a minute, this law is a big problem.
We're going to come back and take a break. I got to let my head wrap around this. We're going to take a quick break and talk a little bit about your organization, and then we'll come right back and start talking about the specifics of what the hell they're suing everybody for right after on the new inaugural show of California Labor Law Odyssey. Okay, and before you go anywhere, we want to tell you there is an organization that has been formed. It's created by our host here, and we're going to talk about a lot in the coming weeks here. It's the California... let me make sure I get it right here. It's CABIA, California Business and Industrial Alliance, CABIA. They're fighting for California's future for you, one business at a time. And they're starting with programs like this, educating businesses about what's out there and then advocating for change. They're also here to try and we hope to do that through the show, give you some actionable ideas of how you can perhaps protect yourself from these lawsuits, or what to do if you're faced with one of these lawsuits, and to just become aware of this lurking danger hanging out there. Go find out more from cabia.org, CABIA.org. All right. Let's go back and see if we can wrap this up a little bit here. So we've talked about the origin of this law. I've tried to understand as much as I can what this law is and how it's structured, and it seems I'd love to have somebody else come in on the other side and give me the defense of this law here. I know at some point I'd love to have somebody come into the show and say, no, they got it all wrong. This is why it's a good thing, and here's why.
I don't think you want to bring him into the studio. I might throw him out the window.
I'd help.
But it must be there must be somebody who passed this law that says, no, this is a good thing. We're protecting more employers. We're correcting more labor law violations. It just doesn't sound like the money's going to the people.
This is a way to make trial attorneys wealthy. That's all it is.
And it's interesting, too, because there have been the proof is in the pudding, right? If this was truly enacted to protect employees, and I think protect's an important word,
right?
There are some significant differences between how PAGA works for wage and hour violations and for employee safety violations. For example,
oh my goodness, that's what we want to go into is the kinds of things that are covered under this and what are they suing for?
Right, and so if the law was properly motivated, you would think that, you're talking about employee safety, protecting employees. Let's talk about physical safety. Under the OSHA part of PAGA, if an employee writes to the state and says, you know what, I cut off a finger and I want to sue under PAGA, the department charged with OSHA in California is required to investigate.
Right.
Okay, they are required to come to a finding. And if they say there has been a finding, then the employee still can't sue. They have to challenge the court and make the court tell the state to investigate. So it's not this send a letter off to the LDWA. If nothing happens, let me bring this lawsuit for millions of dollars.
I'm going to go sue unless you stop me. Right.
Exactly. So under the OSHA statute, or the Cal OSHA statute, you actually have to investigate. The state actually has to do its job.
Right. Because, these people, it could be legitimate, it could be bogus. It could be a way to, as I say, a hold-up just to get some money, or it could be a real violation that should be corrected and paid for. And
you're wielding the power of the state, and I can't impress upon you how important that is. The decisions that have come down around PAGA back employers into a corner. All the typical legal safeguards and rules of reason don't apply because the individual aggrieved employee is acting on behalf of the state, and that's an incredible amount of power to give to someone with a pecuniary motive, like a plaintiff's attorney who gets their 1/3 off the top.
A pecuniary motive. There's a legal term here. They're just out to get money.
That's right. A fancy word. I don't know that one.
So tell me, Tom, what kinds of things they can sue for? What's the list of grievances they can go after a business for?
The one point I just wanted to go back to really quickly, and I think this is interesting. So
this whole thing is interesting in a scary way, yeah.
Well, you were on the $1 million, and
right.
and that was the Google settlement, and so we're talking now about OSHA, and this is. It's sad, but in the San Francisco area, a gentleman died, a forklift turned over, and he lost his life. So OSHA penalized the company for that.
Okay.
So how much do you think the company was penalized for a man losing his life under OSHA?
In today's world, I would expect it to be $1 million or more.
Sure, you would, wouldn't you?
Right.
It was about $56,000.
For losing his life.
For losing his life, but, companies
But if he lost his lunch...
If you took your lunch late, it's going to cost you $1 million, right? So that just shows you how lopsided and inaccurate things are currently right now in today's system.
Wow. And again, one of the common complaints, left or right, I don't think this is just a business versus employer thing, is that we live in a very litigious society, and to a certain degree that's driven up the cost of everything because everybody has to bankroll and protect themselves for that. There's costs associated with that. And I don't know how people listening to this podcast feel, if there's too many lawsuits or not enough lawsuits, but there's certainly a lot of them these days. And it sounds like this has opened up a flood of them.
Well, I think, another thing is people need to realize that a majority of the businesses are small to medium-sized businesses.
Yeah, right.
We're not, we're not all these big giant corporations. And I think that's a lot of people have been cast in that same net. These evil large corporations. And even those corporations
stick it to 'em, right.
stick it to them. And it's not reality. I mean, there's people there that cannot afford these type of situations. So to really take it to a basic fundamental here on PAGA and how things happen. So you could have an employee who you terminated, and you said, I am not happy with this employee.
Right.
So they go and they decide, I'm going to go talk to an attorney.
Right. And under as California laws, I understand it, it's mostly a, what's the term? You know the term here. So I can fire it.
At will.
At will employment, yes. So that means I don't have to have a reason. I just don't like you. I don't think you're doing a good job. Whatever. It doesn't matter. I don't like you. And I don't want you here anymore. Yeah. You're gone.
And that's not a reality. So what ends up happening is they go and see the attorney, and he says, well, I've got fired. And, well, what did you do? Well, I got caught stealing. Mm-hmm. Okay. So they say, okay, well, I can't help you there, but I would like to take a look at your paycheck stub.
Yeah.
That's exactly what they do. Yeah. So they look at the paycheck stub.
I know this because we've had attorneys come in and talk about this. They literally say, let's see if we can find something else.
Right. So what they do then is they look at the paycheck stub, and again, they will say, oh, well, look at this. You got a bonus. How was this classified? It looks like, what time did you take your lunch? I don't see lunches taken out of your paycheck.
I know lunches are a huge one.
Let me take a look at this. And then before you know it, they send a letter to the actual employer, and they say, okay, we think you didn't round up or round down correctly. You didn't give your breaks on time. You didn't give your lunches on time. You did not properly classify the incentives. And they give a laundry list. And they know, hey, out of the 10 items, maybe 3 will stick. But all it takes, Paul, is 1.
Yeah.
All it takes is 1 to stick.
And then they're on a fishing expedition, then do you have to, as part of the discovery, you have to give all this stuff out, and now you realize, I didn't know I was not categorizing things properly. I didn't know. He told me he didn't want a lunch. He told me he'd rather go home 10 minutes early than take his lunch.
Absolutely.
Well, and that's interesting, Paul. That's one of the procedural safeguards that makes PAGA different under California jurisprudence, California law, let's use that. Typically, in order to get discovery, which is the most expensive part of litigation,
right,
an employee must say, look, here's some evidence or some allegations that my experience is like someone else's experience. Because it stands to reason that an employee at worksite A may not know what's going on with lunches or other information over at worksite B. But because it's PAGA, there was a recent case, Williams v. Superior Court, that says that just the mere allegation that something happened to you and that other people were aggrieved similar to you, you get statewide discovery of contact information.
Wow.
Because it's the state. It's not an action on behalf of individual employees.
Wow. So just the mere suggestion, you don't have to show any proof. There doesn't have to be any burden of proof to something you have to show to take it to the next stage. Immediately it goes to that next stage.
Immediately. So let's just say that then you turn everything in and you realize that...
And it's not cheap, I'm sure, to turn everything in, because you got to go, do an internal audit and pay somebody...
You got to look at everything. So they realize, okay, well, it looks like they misclassified some bonuses they were giving, and it looks like they were taking their lunches late. And when we say late lunches, we're talking...
Yeah, how late's late?
It could be 30 seconds late. Anything past 5 hours is a late lunch.
Wow. 5 hours and 1 minute is a late lunch.
5 hours and 1 second.
Yeah.
It's actually 5 hours exactly. After it's more than 4 hours, 59 minutes, 59 seconds.
Yes. At the 5 hour.
At the 5 hour mark.
And it's interesting you say that, because my wife works for a bank. We won't identify which, because I don't want to drag out in this, but she works for a bank.
They need to join CABIA.
They really should. And they are always running around telling her that she has to go take a lunch.
Right.
And she's like, well, I'm in the middle of something. I don't care. Put it down. I'm talking to a customer. I don't care. Stop. Go.
And what's interesting is that that's actually not the legal requirement. The Brinker decision, which set the standard for lunches, is employer must provide the break, which means give someone a reasonable opportunity to take it, not impede their ability to do so. But it's funny how testimony changes once you get fired.
Yeah, right. Yeah, right. So, and she's one of those that says, I'm not big on lunches. I'd rather just get my work done and go home. And they're always like, I don't care. You got to go do a break right now. And they're always jumping on her. And she's like, this is nuts. I don't want to take a break right now. It's either not a good time for me to do it. I'm in the middle with a client. I'm in the middle of doing some project or whatever, or I just don't need a break, want a break. Tough. Go take it.
And it should be their choice, but California's made it impossible for us to be adults because all it takes is for one break to occur at 5 hours. That person gets fired. Hopefully, your wife never gets fired, but that person, theoretically, they do.
Right.
And now they can bring a PAGA action on behalf of her and everyone else in the state of California.
I think the state needs to tell us what to do, though. I appreciate them telling us what time I'm supposed to take.
We don't know what we're up to, so yeah.
Yeah, right. And then somebody has to write down when this lunch, because not enough I just went and told you. Somebody has to verify, and that means did all your supervisors at the right time keep the right records? Because if maybe they did take the right break, but there's no record of it, would that cause a problem?
Yeah. When you
don't have the record.
Oh yeah.
We fight this at my firm quite frequently. There are some cases out there that say if the records show a late lunch, there's a presumption that the lunch wasn't taken, but no records at all are definitely a bad place to be in. So a lot of the first thing that we do when we get a lawsuit like this is we actually break down the records, throw them into Excel, type in formulas, and say, well, here are your 50,000 lunches that were late by 1 minute, and here's your $500,000 exposure.
So give me an
number.
estimate. There's, I don't know, how many businesses do you think there are in Orange County or Southern California in general? I have no idea that are in that small to mid-size range that, 50
probably
to
300,000.
300,000. We're just taking a wild guess, say that, and these have what, 100 employees or 50 or 60 or up to a couple hundred employees, somewhere in that kind of mid-range. Let's say there's over 250,000 of these companies. Give me a wild guess. If we just called them all up and went in and did our own little audit, how many of them are in compliance?
Nobody.
2%.
Nobody.
2%, maybe.
Everybody's got some form of viation. I'll give you.
That's correct.
Yeah.
Lunch is probably 2%.
I'm talking some form of violation. Don't forget about the 1,400-page labor law digest. I mean, let me just tell you something. I went and I used the restroom here, Paul, and I might have to file a complaint because
please God,
it was a little bit cool in here. And if the restroom's under 68 degrees, that's a labor law violation.
What?
And I can file a PAGA lawsuit.
And for what? What's the discernible damage?
It was too cold to go.
And funny you should mention damage.
Don't you have to, in a lawsuit, don't you have to...
Not with PAGA.
I mean, I can sue you for whatever I want, but the court says, but what's your damage? I can't... Okay, I'm sorry. Sorry the dog barked at you. What was your damage?
Yeah. Well, I mean, to take you back to... We're back to the example of... the employer that is having their employees take late lunches and misclassified incentives. So PAGA only goes back 1 year. So once the employee goes and gets the attorney and you have this PAGA lawsuit in place, so you've let the fox into the hen house.
Yeah.
So now they start to look through the information. And what ends up happening is, say you have 50 employees, and out of those 50 employees, you got 3 or 4 that are at minimum wage.
Right.
And those minimum wage employees didn't take their lunches on time. They took it half an hour late. So we owed them, or they owed them, 1 hour worth of lunch. Well, at that point, because you didn't pay them the 1 hour's worth of lunch, they were making less than minimum wage. Then what happens is they can file, I don't know what the number is, it's the 299 or something. So what ends up happening is you're not competitive for competitive reasons.
Oh, 17,200.
Right, and then they turn that into an additional 3 years, because then that becomes a 4-year.
Yeah, so what Tom's talking about is...
Help me out on this.
Yeah, so there's a law out there called the California Business Professions Code, Section 17200, and it's the unfair competition law.
Unfair competition.
And the idea is that if you in any way violate the labor code, because everyone's supposed to be compliant with the labor code, you're unfairly competing against your competitors. And
because you're paying them less or whatever.
Yeah, exactly. You're doing something that's unfair, right? It's a squishy term. And so what happens is that has a 4-year statute of limitations, because the remedy, unlike damages, is what's called restitution. And restitution, the way you want to think about it is, let's say I give you $100 to paint my house, and you screw up and somehow ends up costing me $300 to get it fixed, that would be damages.
Yeah.
But the restitution is, give me my $100 back.
Right.
I mean, let's reset before the contract was created.
Yeah.
Because it's got a different remedy.
Again.
Exactly. It's got a different statute of limitations. So what Tom's talking about is you can use these different legal theories to kind of maneuver your way into longer periods of time, more money.
Because we've had people come in, and some labor law attorneys over the years here in the station, and they said, "Oh man, you won't believe it. They're going to go back years then and penalize you for missed lunches and missed breaks and all this stuff here, and plus penalties and plus. Oh my God, you're looking at millions and millions of." So, for example, we let's just, another thing we've talked about. Maybe we'll just clarify this. We are in an at-will state. They can fire you for any reason except if you're protected category, or they can't fire you because of race. I don't like your race. They can't fire you because of religion. They can't fire you because of what? Sexual orientation?
Well, to be fair, you can't fire anyone in California because protected categories basically cover everyone.
Okay. But theoretically, it was supposed to be, you could fire, you're employed at will, so you have no expectation. There's no guarantee of a job. I can let you go anytime, except if my reasons are, reasons we've decided as a society wrong.
The exception swallows the rule, right?
Yeah, you can't fire somebody because of the color of their skin or their race or their religion or whatever.
Which is a good law. I mean, I get that.
So what we're hearing is that somebody comes in saying, "I've been fired," and they say, "Are you one of these protected categories?" Well, no, I didn't get fired for that. I didn't get fired because of age. I didn't get fired because of racial discrimination or religion or whatever the other categories. I think there's only 3 or 4 of them. And they said, "But I still got fired, and it's wrong. I shouldn't have been fired. It was unfair. It was wrong. Whatever." And they'll say, "Well, sorry, there's nothing we can do about that. You live in an at-will society. But, yeah, tell you what, bring that pay stub in."
Would you like a real-life example?
Yeah.
So I recently defended a company. I'm going to keep it because I have another potential lawsuit coming against the same one. Essentially, this individual forged a safety document that involved noxious gases that could have damaged a subordinate. And he lied about it, and he was terminated for an egregious safety violation.
Wow.
He was properly canned.
Yeah.
And he went to an attorney. He said, "Well, you know what? I'm looking at these lunches here, and I know you've got an arbitration agreement. Looks like maybe these bonuses might be properly classified. I'm going to bring a PAGA action." And again, because the reason he was canned had nothing, it's not an excuse for a wage and hour violation.
Right.
This threatened PAGA action would have cost the company, just to defend it, probably all the way through trial, maybe close to $500,000.
So they fired a guy for doing something really bad.
Really, really bad. And
then he came back and bit him in the butt because he found other things. Mm-hmm. "Oh, fine, you're going to do that to me. I'm going to do this to you." And
the attorney was straight up about it. He said, "Look, I know he was canned properly, but you know what? This is going to cost you a ton to defend." So they walked away with close to $60,000.
Wow.
Now the other thing that you got to remember is
wow.
when you go back 4 years, right?
Uh-huh.
So back to the example of 50.
Well, to be clear, let's make sure PAGA's only one. But we're talking about the unfair competition
once
law
we
now.
open up unfair competition.
So PAGA lets you in the door, and then you try and find other things in addition to PAGA.
Right.
So you came to this attorney because you thought you got fired unfairly. You part of a protected category? No. You did something really bad. You did something. Sorry. They should have fired you. They can fire you. But let's see what else we got. And they start looking through that, and they use the power of PAGA to open up all these other cans of worms here, and these what many of us would think are petty violations, but maybe that's just a business owner's point of view. But these small violations get multiplied into millions of dollars suddenly here. And then, because of the power of PAGA and the state behind it, I'm going to rip through everything you got. "Oh, I see you were unfair, and you did this, and you did this, and oh my goodness, the more I dig, the more I find. So get out of here. Here's $1 million. Go away."
So where it really starts to get expensive. So now we open up the can of worms. We're able to go back 4 years. You've got the 50 employees, but now you got to account for, in the past 4 years, how many employees do you have that worked for you that no longer work for you?
And I got to go find them.
And the real issue on those employees is, because I gave them an inaccurate paycheck 2 years ago, I owe them 30 days worth of pay.
Wow.
So if I have 50 current employees and 25 past employees, those 25 past employees I'm going to end up owing 30 days pay on.
This just gets worse and
It's
worse.
worse
and worse.
than that, though. No, so
It gets worse. It gets worse before it gets worse.
Yeah. So what Tom's talking about is Labor Code 203. In Labor Code 203,
He's got those numbers down.
Yeah.
Yeah, well, I see them all the time. I saw two this morning before I was.
Because some
picked
people are
up
going to want to say, I don't believe this, and I got to go check this
Labor
out.
Code 203, it provides for anyone who was terminated, whether voluntarily or involuntarily, if you not provide them every single cent that they are owed, they have what are called continuing wages until the employer corrects a violation. Now, Tom's example alludes to the fact that fault is not an issue here. It need not be intentional. Indeed, they do not care if it's a mistake. It does not care if it's an error. So these things are not discovered until a lawsuit is filed. And so each individual gets 30 days of pay, which is about a month and a half, because
Wow.
it's not work days. So, but that's not the bigger problem. Is the PAGA penalty for inaccurate wage statement?
Yeah. Why don't you go through the penalties for us?
Yeah,
Rob?
that's right.
tell
Let's
us.
do that. So let's start with when we're stick with PAGA here. I could go off on 203s, and I might have time for that later.
Because PAGA, what we're saying is
what
PAGA
we're
can
on to
open
do
the
today.
door, all these other potential violations.
Right. So let's the PAGA.
203s. I think I'm going to need a 7 and 7 on that one.
I'm going to need a Colt 45. I don't know. Go ahead.
So the PAGA penalty statute works like this: for each initial violation, it is $100 per employee per pay period, and so that can mean 2 weeks. It can mean every week. Depends on how you pay. And indeed, all non-exempt employees in California, which means non-exempt and non-salary, not the exact same thing, but most non-salaried employees are non-exempt.
Right.
Must be paid at least semi-monthly, at least twice a month.
So hold on one second. Let me just ask this question, Rob. And I don't mean to interrupt, but
Please.
So if I'm
My head's swirling.
if I'm an exempt employee and I'm salary and I don't take my lunch or I don't take my break, I can't file a PAGA lawsuit?
Well, you can file a PAGA lawsuit, right? Because the premium pay is it would be interesting, right? Because you wouldn't have a labor code violation because for an exempt employee, the premium pay is an hour of work. So I don't think you get anything under labor code. But yeah, I don't think labor code. I don't think meal periods apply to exempt employees.
Wow.
Yeah, I have to look that up because I don't really typically see these in the salary context.
So can I ask you a really awful question? I don't want to start a stampede of lawsuits, but why wouldn't every employee of every firm be running to get an attorney to say, see what you got, see what you can find, because it sounds like there's some free money waiting for me there.
Because not all people are like that. It's only the good nature
But
of people.
it shows
every
you,
employee could.
Yeah, it shows you how screwed up the labor law digest is because it does not cover exempt employees. They don't care about them, just the non-exempt employees.
Right.
So,
And there might be a reason. I'll have to look that. It's a good question, Tom. And you stumped me for once.
Wow.
For once.
All right.
God.
Well,
now I'm embarrassed.
All right. So we've only got a couple minutes left to wrap this up.
knock out the penalties.
Should I wrap up the PAGA structure? Yeah. So the PAGA structure works like this. For any violation of the labor code, keep in mind that's your 1,700-page document.
Right. 1,700 pages. Because we said we were going to list them. We really haven't. But some of the big ones are what? That seems to be missed lunches is a hot one.
Meal breaks, rest breaks, pay stub violations, what you call non-payment of minimum wages, which is not really
misclassified incentives are really big.
Exactly.
Gift cards. Be careful on gift cards.
Yeah, a bonus that you give that you don't recalculate into
These
the
are
regular
hot
rate.
buttons that the attorney's starting to look for.
Exactly.
Right.
They're very easy to catch. Wage deductions, not reimbursing people for cell phone use or driving, stuff like that.
But it could be as ridiculous as the example you came that my bathroom was too cold and I couldn't pee.
And I'm still struggling over that.
So the penalty structure is $100 for the first pay period or $200 for every violation thereafter. But that's what you call the default, or what I call the default
But
penalty.
could that go on for years?
It goes on for 1 year. It's a
1
one-year
year.
statute of limitations. Now, Tom alluded to wage statements. Where the labor code prescribes a larger or different penalty for a violation, that one will apply. So, for example, a pay stub violation.
So if there's two penalties and the bigger one always wins out.
If it's prescribed, right? If it's the way it works, like most of these, if it's you have a meal break violation, it says you get an hour of pay under the statutory penalty, but the statute doesn't say here's a civil penalty equivalent. If there's no civil penalty equivalent, 100, 200. If there is a civil penalty equivalent, for example, pay stub violations, Labor Code Section 226.3, then the first violation is $250
per employee.
And the second one is $1,000 for each violation. And keep in mind, you do
For
not
each
have
violation for each employee.
for each violation for each employee, and you do not have to show any injury whatsoever. Tom has a great example with the employee IDs. I'm not going to steal it from you.
Oh, okay. So there's a company in Sacramento that apparently their check had one employee ID number on there, and their badges had a different employee ID number. No harm, no foul. Everybody got their money, they got their lunches, they got everything on time, but they had the wrong employee ID number. It's going to cost them $1 million.
As well it should. What a horrible thing to do to people, to have two employee ID numbers.
What? It's shocking. I mean,
that's just so obvious. Come on, that's $1 million.
And people don't believe it, but that's the issue with these laws, and that's why we're trying to tell people, we're trying to educate.
So
people.
why isn't every employer up in arms? Why aren't there 1 million people at your rallies? Why aren't we having protests marching up and down the streets here? Why aren't we camping out in the steps of Sacramento?
That's what we need to do. That's I think we need to really take a hardline approach and say enough's enough. Draw a line in the sand. They can't continue to pass these kind of laws and make it worse, make it more complicated.
Because you're saying of the 300,000 small to mid-sized businesses who think they're safe and are doing everything right, they're all at risk.
They're all at risk.
I often lecture on this situation, and every time I open my presentation with is y'all breaking the law. Yeah. Every single one of you.
Yeah, whether you know it or not.
They are.
And maybe you could make a rap song with that.
Y'all make it up. And the potential for you to have couldn't this cripple most businesses? Couldn't they put them out of business?
A lot of them go out of business.
Except, thankfully, the California legislature in 2016 passed Labor Code Section 558.1, which means that you can now sue people individually that own businesses and high-level managers. So a lot of times at mediation will say, look, this will cripple the business. This will make the business will commit will go into bankruptcy.
Will commit suicide.
Yeah,
right.
But no, 558.1 allows people to sue someone personally. So the LLCs, the corporations have no meaning in California thanks to 558.1.
If it's a PAGA, labor law, whatever.
Non-payment of wages claim.
Right. Wow. I look forward each and every week to breaking this down into tangible examples and wrapping it around. This is a frightening overview. We all tend to live, I'd say we follow the minnow mentality. I'm in a sea of minnows. There's so many of us out there. Nobody's ever going to look at me. And you're saying, rather foolish way to exist if you don't find ways to prepare for this, deal with it when it happens, or even better, band together as a group of minnows and see if you can't become a shark, have a bigger bite, then you're all open to the opportunity of getting bit in the butt big time.
Yeah, big time.
Okay. Thank you, guys. Where do they go to hear more information? Give us some sites or resources.
Cabia.org, CABIA.org, and you can call me. Tom Manzo, 818-823-7611.
That's a
mistake right there.
That's it. Because as we're going to talk about in the next episode.
You're going to bleep that out.
Because we're going to talk about in the next episode. This is episode 1. Episode 2 is going to be about your story and how you had this happen to you. You're like the hair club. You're not just a businessman. You're a member of the club here. Yeah. You got bit in the butt big time, and that motivated you to take action and form this organization and start to speak out on what you think is a very, very potentially damaging monster lurking in the shadows out there. All right, we'll come back and do that story right next. But thank you so much for tuning in. Don't run away. Don't tune out. Don't just give up. There is hope. But first, we got to tell you the real fear of what you're facing right here on the new California Labor Law Odyssey.